Hello and welcome to Win Without Law School. I'm Arizona lawyer Julie Labenz. Today we are going to talk about ways to settle a case in the post-decree, post-order context. So if you have a modification and or enforcement matter pending, what are some options to try to settle the case? Now, in earlier videos, we talked about trying to settle before you file. We talked about trying to settle right after you file. So this is, again, talking about ways to potentially settle, but this is focusing more on when, the case is a little more further developed, disclosure's been done, you've probably had an RMC, and we'll talk about RMCs here as well, because that's one of the options. But looking at some other tools available to potentially get your case settled without having to go to trial. All right, if you have a modification case, then what is on the table to negotiate and settle? Well, you need to look at, number one, what is in the petition to modify? Is it legal decision-making? If so, then legal decision-making would need to get resolved. Is there a request to modify parenting time? If so, you would need to resolve that issue. Is there a request to modify child support? Are you negotiating just the amount of child support? Are you negotiating medical insurance coverage for the minor children, the division of uncovered medical expenses, and or the division of the child tax exemptions? So again, look at the petition to modify, see what's actually being requested for modification. And then spousal maintenance. Is there a request to modify spousal maintenance? And then a final potential issue to resolve are legal fees and costs. If either side has made a request for legal fees and costs, and that's at issue in your case. What if you're facing an enforcement action? Well, again, look at the petition and see what's at issue in the petition. So is there a request to enforce legal decision-making, parenting time, child support? It could be for non-payment of child support, failure to provide medical insurance, or failure to pay their particular share of the uncovered medical expenses. Is it to enforce spousal maintenance, or is it to enforce an order from a divorce, within the decree dividing property? And then if legal fees and costs are requested, if that's at issue in the case, then that would be another issue to settle in order to get a full agreement in place. All right, let's look at some of the options for trying to resolve your case through a settlement. Number one, you could negotiate directly between you and the other party or with their lawyer if they're represented. You can try to reach a settlement in the context of the Resolution Management Conference. You could try to reach a settlement through mediation. It could be private mediation or through the court. Or you could try a judicial settlement conference, which is essentially where the judge acts as a mediator. So those are various options available. Let's first focus on the option of negotiating. If you want to engage in negotiations, I suggest you start by making a written offer with a deadline. So be clear about what the terms are. What exactly are the terms of your settlement offer? Make those very clear, put them in writing, and include a deadline. From there, you can seek to negotiate with the other side. And if you reach an agreement, you can put the terms of your agreement into a written agreement and a stipulated order. So once your agreement is in writing and in the stipulated order, both parents would sign the stipulated order before a notary or court clerk. And then you file the completed, signed, stipulated order with the court. When the judge signs and enters it, your case is resolved. Let's look at the paperwork to use if you're seeking to modify. So we're looking at settlement paperwork if you have a modification case and you've settled the issues that are in dispute, which could be legal decision-making, parenting time, child support, and or spousal maintenance. So what if the pending issues are modifying legal decision-making, parenting time, and child support, and you reach an agreement? Well, you can use this form. It's a 2-page form, and this is about your agreement to modify. So obviously you'd fill out the case caption, and this is saying that the two parties agree and understand that that they've read the document, they understand and agree with what is written in the stipulation and order. Legal decision-making, parenting time, and child support shall be ordered in accordance with the attached order, which has been approved and signed by both parties. Some information about the prior order that's being modified. And then the agreement regarding legal decision-making, parenting time, and child support is in the best interest of the minor children. And then both sides would sign before a notary or a court clerk. And along with that 2-page agreement form, you would also use this proposed order form. And you may remember back here, that's what was being referred to here. Shall be in accordance with the attached order signed by both parties. So this would be the order to attach, order modifying legal decision-making, parenting time, and child support. So here's where you put in the names of the children, indicate joint legal decision-making, if that's what you're agreeing to. Or let me see here, this says, yeah, if requesting joint legal decision-making, then you have to indicate there's been no domestic violence or no significant domestic violence. The date of your prior order that you're modifying, and then what's happening with legal decision-making, what's the agreement, child support, what's the agreement, medical and dental insurance, vision payments, what's the agreement, and then tax deductions, any agreement to that effect, any other orders, and then you'd leave this blank. That's for the judge to sign, but you could see here's the page for party A and party B to sign, and they would sign before a notary or a court clerk. And then if you've reached an agreement to modify child support, you must file with your stipulated agreement and a post and proposed order additional documents, your child support worksheet, your child support order, and the employer information form, also known as an income withholding order. I mean, they're not the same forms, but in Maricopa County, they have you submit this employer information form, and then that goes into an income withholding order. While in other counties, they have you submit the income withholding order itself. So as a reminder, this is what the child support worksheet looks like. This is a blank one. So this would be filled out with the amount of child support for the amount you're asking the court to modify to. And then here's what the child support order looks like. When you draft your child support worksheet, it's through an Excel spreadsheet, and you'll end up having some tabs that you can click on that will take you to the proposed order form, and it'll auto-populate based on what you put into the worksheet. And so just review it, make sure it's all good to go, and that would be your proposed child support order. And then this is the current employer information form for Maricopa County. And then here's what Yavapai County's income withholding order looks like. It's a 5-page document, and you fill out the information in here. The court clerk can help you with it as well. But just to give you some, more detailed information about what we're talking about here, if child support is ordered or spousal maintenance or it's modified, this order, the income withholding order, goes to the employer of the party ordered to pay. And then this orders the employer to withhold a certain amount from each paycheck that will then be transferred to the support clearinghouse to pay child support with. So that's what an income withholding order, it's an order to an employer to withhold income from someone who's obligated to pay child support or spousal maintenance, and then transmit that money to the clearinghouse so that the payment can be recorded and then the money can be turned over to the party entitled to receive it. Okay, so this is just the income withholding order form for Yavapai County. It's used in other counties too. And then now let's look at, well, what if legal decision-making isn't being modified, but only parenting time or only child support or parenting time and child support? You can use this form. So stipulation to modify prior court order regarding parenting time or parenting time and child support. So you can fill this out. This is the agreement section. Again, you need to sign, both need to sign before a notary or a court clerk. Here's the agreement just for child support, if you're looking to modify that. And then here's the proposed order modifying parenting time and or child support. So you can see you need to grab the proper agreement form and then and then use it in conjunction with this proposed order modifying and fill it out based on the agreement you reached. And again, this is signed and notarized, or it could be signed before the court clerk. And then if you're modifying child support, then you also need to include your child support worksheet, your child support order, and the employer information form or the income withholding order. So just again, as a reminder, this is the child support worksheet. This is the child support order. And then here's the current employer information form and the income withholding order. What if the issue in your case is to modify spousal maintenance? Well, here is the form for an agreement to modify spousal maintenance. Now, the court didn't have one of these, so I made one. And all the parts that are in red, that's what you'll need to fill out. But this is an agreement to modify spousal maintenance. So you fill this out based on your agreement. Here's the signature page with the notarizations. And then here's, I created a proposed order modifying spousal maintenance. So again, you'd fill out the parts in red, and this would get submitted with your agreement. Now, we just covered modifications, but what if your case involves enforcement? And you could be enforcing legal decision-making, parenting time, child support, spousal maintenance, and or property division. So let's look at an agreement to enforce child support. Again, the court didn't have a set form for this, so I made one for you guys. The red parts are what you're going to edit to or tailor to your case. Here's that signature page with the notarizations. And then here's the proposed order. And I named it an arrears judgment because if you fall behind in child support, that's the remedy, is to get a judgment against the other side for the amount of child support that they owe. And then once you have an arrears judgment, the court can also order that the party that owes the money pay a certain amount per month towards that judgment, and that gets added on to the child support obligation. So you can see here, amending the income withholding order to include the child support arrears judgment, and that the obligor pay a certain amount per month towards the child support arrears judgment. So you'll want to put in your proposal for how much you want them to pay per month towards the judgment. Now let's look at an agreement to enforce spousal maintenance. So again, the court didn't have a set form for this, but here's the agreement to enforce. And then a proposed arrears judgment for spousal maintenance. And same thing with spousal maintenance, you can amend the income withholding order to include the arrears judgment and include a certain amount to be paid per month towards that arrears judgment. And then an agreement to enforce property division or an agreement to enforce legal decision-making and or parenting time. I recommend you work with a lawyer on that, especially for the property division. It can get really complicated. And since there's property involved, you are not going to, want to mess around with that. You're going to want to get it right. So obviously, if anybody has questions on that, we can address that. But it's so case specific that it was hard to draft some sort of basic template or, basic order, because who knows what type of property you're looking to enforce. And then with legal decision-making and parenting time as well, it gets really case specific. And I want to go back for a minute, because just remember that with these enforcement documents, if you're getting an agreement to enforce spousal maintenance or to enforce child support, then you will need to include that new income withholding order if you're wanting changes to be made regarding how much is withheld from the paying party's paycheck. Okay, so we covered these. Let's now look at another settlement option, which is through a resolution management conference. What is a resolution management conference? It is an opportunity for the parties to touch base with the judge give the judge the status of the case. If any agreements have been made by the parties, those agreements can be formalized. And then also you can ask the court to take the next steps in your case. So if you're wanting a trial set or if you're wanting mediation, you can ask the court to schedule those types of things. Now, in general, the court will schedule an RMC 40 days after a response is filed, but here we're in the post-decree context. And in post-decree, the response is optional. So often what happens in post-decree is that when the person files the petition, they also are obtaining an order to appear, ordering the other side to appear at a resolution management conference. So the resolution management conference usually happens a bit faster in the post-decree context than it does for a petition to establish or a petition for divorce. But the bottom line is, in almost every family law case, a resolution management conference is set by the court. If a resolution management conference is set in your case, then read the orders setting the resolution management conference and see what your deadlines are. Often there's a standard deadline of 3 days before the hearing, and those would be 3 business days. However, sometimes the court extends it to 5 days. I know in Yavapai County, that's very common to use the 5 days. So read your order and see if it's a 5 days before or 3 days before, and those are going to be business days, days the court's open. And that's when you're going to file what's called a proposed resolution statement. And that's going to have all of your positions in there regarding on what terms would you settle your case. And so since each party is filing this proposed resolution statement, if you look at the statements or if the parties talk ahead of time through the meet and confer and see that there are any points of agreement, those agreements could be put on the record in a Rule 69 agreement at the RMC and made into a formal order of the court. So, we're talking about ways to resolve your case without a trial. The resolution management conference is one way to get any agreements that you do have with the other side made as a formal part of the case. So here's what the order to appear for resolution management conference post decree looks like. And so you can see here how to prepare. At least 5 days before, each party must file with the clerk of court, provide to the opposing party, and provide a resolution management statement to the judicial clerk. So at least 5 days before, you've got to do your resolution management statement. And then at least 5 days before, you need to do a meet and confer with the opposing party or their lawyer, unless there's an order prohibiting contact between the parties due to domestic violence. And so that they've got the 5-day deadline here. So 5 days before, again, business days, you file your proposed resolution statement, complete your meet and confer. And if the parties are in agreement on anything, they could formalize that at the RMC through a Rule 69 agreement. Now, there was not a proposed resolution statement in the set forms for a post-decree case. So you really need to tailor this document to fit your matter. So you can, cross out paternity, and then whether, depending on what issues are involved in your case, if legal decision-making is, you could leave it in. If not, you could cross that out. And then start filling this out the best you can, but realize that this form is really for like a custody establishment case, not necessarily a post-decree case. So you will need to do some editing of this document, but do the best you can. Here's the mailing certificate page. And then any agreement between the parties is valid and binding if the agreement is in writing and signed by the parties, if the agreement's terms are stated on the record before a judge, or the agreement's terms are stated in an audio recording made before a mediator or settlement conference officer appointed by the court. So those are 3 ways to lock in an agreement and make it valid and binding. An agreement is not binding until it's been submitted to and approved by the court. An agreement is presumed valid, and a party who challenges the validity has the burden of proof. And that can be really difficult in the context of a Rule 69 agreement to undo it. Okay, let's talk about another settlement option, which is mediation. So this is under Rule 67.3. You can do private mediation or a mediation through the court-appointed mediators. All communications related to mediation are confidential. So just keep in mind, if you do mediation, you're not going to be able to go to trial later and testify about what the other side said in mediation because it's confidential. So you can't use anything against the other party that came up in mediation at trial. The mediator also can't tell the judge about the details of what happened at the mediation other than what the outcome was and things like that. Okay, the parties may privately mediate any issue in dispute. The parties, if they're going to use a private mediator, they should file a notice to the court about that. The parties may ask the court to select a mediator for them from a list of private mediators. The parties must contract directly with a private mediator and be responsible for the payment of the fees. The court may enter an order referring a matter to mediation. However, so this, what we're looking at is either side could request that the court order mediation. And if you're opposed to mediation, then you'll likely want to argue something that fits within these parameters. So the court can decline to refer a matter to mediation if it appears that mediation is inappropriate because of parental unfitness, substance abuse, mental incapacity, domestic violence, or other good cause, or because mediation will cause undue delay. So if you're opposed to mediation, you likely want to put your objection into these terms. So, judge, mediation is inappropriate because the other side is a drug addict. I'm just simplifying it. So that's a suggestion. If there's been domestic violence, then the court and the mediators are supposed to make sure that nobody feels harassed or intimidated or that they may be harmed. And the mediator can end the mediation if there's concerns about domestic violence. The parties have the ability to waive mediation, and the mediator can terminate mediation, in particular if domestic violence makes mediation inappropriate. If you filed for default and you're going to mediation, or if you want to pursue a default, but you're going to mediation, you've got to do the mediation first before pursuing the default. All right, scheduling. The court will refer the matter to mediation, and then the mediator will schedule the conference. The mediator may permit persons other than parties and their attorneys to attend if those persons agree in writing to be bound by the confidentiality provisions. And then counsel for a party could be excluded from a private mediation conference if the party and counsel agree. A conciliation court mediator must authorize, or conciliation court policy may authorize the exclusion of counsel. What I generally find is that, at least in Yavapai County, there'll be a certain, if a matter set for mediation, then a deadline is also set for counsel to indicate whether or not they're going to appear at the mediation. So the presumption is that counsel will not be there. And if the counsel is going to be there, they have to file a notice. The parties are required to appear at mediation. If they fail to appear, they could be sanctioned. Failure to complete mediation, the court will not continue a scheduled trial or hearing based on a failure to complete mediation unless there's good cause shown. The mediator may require each party to submit a mediation statement prior to the mediation. You don't file it with the clerk. It would only go to the mediator. And if you have to do a mediation statement, then this A, B, C, and D, that's what needs to be included in it, which is a description of the issues in dispute, your position on each issue and the evidence in support of your position, your current AFI, any other financial numbers that are involved in your case. For example, if it was a petition to enforce child support, this is where you include the information about the unpaid child support, a summary of any negotiations you've had previously, and any other information you believe will be helpful in resolving the issues. Any binding agreement reached by the parties during a private mediation must comply with Rule 69 Any agreement between the parties during the mediation must contain their acknowledgement that they entered into the agreement voluntarily. They have full disclosure of all relevant facts and information. They intend the agreement to be final and binding. They believe the agreement is fair and equitable. If the agreement impacts children, they agree that it's in the best interest of the minor children. The parties must notify the court when the mediation is concluded, if you did a private mediation, and advise the court of any agreements that fully resolve their issues. The parties must provide this notice not later than 10 days after the mediation concludes. If the parties reach a partial agreement or no agreement during mediation, the mediator must file a brief report to the court stating that the parties met and attempted to resolve their differences, but that mediation was unsuccessful. We just have a comment here saying that attorneys are not allowed at mediation used within a 30-day review. So yeah, the court can make orders about the mediation. So yes, the court could make a specific order excluding attorneys from a mediation conference. And that could be in the court's local rules as well. Now there's a standard policy with the courts that cases that involve legal decision-making or parenting time would be subject to mediation. So often the courts will refer any sort of legal decision-making or parenting time dispute to mediation. And you can request that the court set mediation, and we're going to look at that form in a minute. Any agreements reached as a result of mediation must be in writing. And if an agreement is reached at mediation, then there's this 30-day objection window. So if either side is represented by an attorney, they get 30 days after mediation to approve or object to the agreement. And then the court has the final authority to accept, modify, or reject an agreement. So here's the request for post-decree mediation. This is if you are requesting it and the other side has not agreed with you. And then here's the joint request form if you and the other side are in agreement to mediate. Now, I did not find a post-decree order referring to mediation. So this form will need to be tailored. Anytime it says pre-decree, pre needs to be changed to post because this is here in the post-decree context. So. All right, let's talk about the final settlement option. This is called a judicial settlement conference. On a party's motion or on its own, the court can order the parties to attend a settlement conference. If the parties agree, the assigned judge or commissioner may conduct the conference. So if you request a settlement conference, you have a choice. Now, in some counties, you don't have a choice. It always just goes to a different settlement judge who handles these. In the more rural counties, you'll have a choice to have the assigned judge hear the matter or to ask that a different judge handle the settlement negotiation. In general, judges cannot communicate ex parte, meaning with one side and not with the other, but that is allowed at these settlement conferences. And so that's where both parties have to acknowledge, yes, I understand that ex parte communication is going to happen here, but I agree with it in terms of the settlement conference. So the court may order the parties, their attorneys, and any other person who the court deems necessary to facilitate settlement to attend and participate in a settlement conference. The court may enter an order setting the date. The court can order that each side submit a settlement memorandum. If the court orders a settlement memorandum, it is not filed with the court. It is just submitted to the judge's assistant. And the memorandum would include these 4 points, just like in the mediation memo, it's the same thing. So a description of the issues in dispute, each party's position on the issues, evidence in their favor, your AFI and any evidence regarding financial matters, a summary of the negotiations thus far, and any other information you believe would be helpful to settling the issues. So this is about that ex parte communication. You're waiving that if you're having your judge handle the matter. Domestic violence, the court must put reasonable procedures in place to protect the victim from harm, harassment, or intimidation at the settlement conference. If any agreements are reached, they can be made binding through a Rule 69 agreement, so long as the parties acknowledge that they're entering into it voluntarily, they have all the information they need, they want the agreement to be final and binding, they find the agreement to be fair and equitable, and they believe it's in the best interest of their children, if children are involved. Okay, and then just even if you don't do a Rule 69 agreement, the agreement can still be valid and binding if it's in writing and signed by the parties. Stated on the record, that would be the Rule 69 agreement, or, this audio recording with a mediator. But ultimately, the judge still has to approve of the agreement. And if either side is going to challenge the validity of the agreement after it's been entered, then they have the burden of proof. And that can be very difficult to undo an agreement. So here's, they didn't have a set form for this, so I created one for you. This is the motion to set judicial settlement conference. You could make this motion on your own, or if the other side's in agreement with you, then it could be a stipulated motion. Anytime you file a motion, you need to file a proposed order. So here's the proposed order setting judicial settlement conference. And of course, you'll want to tailor all of the red parts to fit your case. And then if you're ordered to do the confidential settlement conference memorandum, either in the context of a mediation or judicial settlement conference, here's what it looks like. Here's the issues, general description of what's in dispute. You could have spousal maintenance on here. You could have property division. You'll need to tailor this to your case. AFI, a proposed worksheet if you're looking to modify child support, the negotiations thus far, any issues you think would be helpful for the judge to know. So all of that is there. Okay, we've reached the end of today's lecture. So just as a quick summary, if you are looking to try to settle your case and avoid a trial, you can engage in direct negotiations with the other side. And if you reach an agreement, then you'll want to put that into a written agreement and a proposed order and file it with the court. You can try to reach an agreement at the RMC, and if that works out, you can formalize it and make it binding through a Rule 69 agreement. Mediation, you can try that either privately or through the court. If you reach a mediation agreement, or if you reach an agreement at mediation, then it would put into a mediation agreement, either written agreement, or it would be recorded, like an audio recording. And then there's a judicial settlement conference where if you reach an agreement there, it can be formalized and made binding through a Rule 69 agreement. All right. There's a question. Are we always the respondent or petitioner based on what we were listed in the divorce decree? Yes. So even though in the post-decree context, the respondent could be the party that filed the petition to modify, they still remain the respondent in the case. And the petitioner respondent, those designations will stay the same throughout your case. That's a good question. All right, thank you guys. Any other questions you have, please bring those into the Q&A.